Good afternoon, everyone. Please take a seat. Somebody could close the door. Great to see the room full. And it is my great pleasure and honor to introduce our keynote speaker, Professor Eric Posner. He doesn't need so much introduction, but I'll do it anyway. So Professor Posner is the Kirkland and Ellis Distinguished Service Professor of Law at the University of Chicago Law School. His work spans antitrust law, financial regulation, and constitutional laws. He has written a dozen books and more than 100 academic articles on law and legal theory. I believe he's currently on sabbatical at NYU, right? From 2022 to 2023, he served as counsel to the Assistant Attorney General for the Antitrust Division at the US Department of Justice. And if I'm not mistaken, was quite involved with the merger guidelines, right? So that have been brought up a few times today. For our purposes today, what matters mainly is that Professor Posner is arguably the most influential scholar in the field of labor antitrust. His writings, including his landmark book, How Antitrust Failed Workers, and his antitrust law journal article, The New Labor Antitrust, are essential reading for anyone interested in how competition rules apply to labor markets. His ideas have truly reshaped the way scholars as well as regulators think about antitrust in the labor markets. Professor Posner will speak for about 45 minutes, followed by around half an hour for audience questions. So please join me in giving a very warm welcome to Professor Eric Posner.
Thanks very much, Jan. Thanks so much also for inviting me to come speak, and thank you to your other organizers. Let me jump right in. So I'm not going to talk about the empirical research about labor markets that was talked about today in the first panel. I've put that up on this slide. I'm sure many of you or most of you are familiar with this famous map of concentration across the US. And the literature that suggests that mergers often reduce mergers in concentrated labor markets often reduce wages, and the other literature on this. Let me jump ahead just so that we're all on the same page. This is just a supply chain, and the workers supply inputs to a firm, and then the firm turns around and sell goods to the customers. And one of the reasons I put this up, not to teach you about monopsony, you know what that is, but just to emphasize the symmetrical nature of this relationship. Monopoly and monopsony are exactly symmetrical. The only difference, which of course is crucial, is that monopoly leads to higher prices and monopsony leads to lower prices or wages. But they both have the same effect, holding all else equal, which is to reduce output. And so this causes harms on both sides of the market. So if you have if monopolization occurs in the product market, that will reduce demand for the product, which will hurt people on the labor market side. And similarly, if monopolization occurs, there'll be fewer workers, and all else equal, that will result in less output and higher prices for consumers. And I think an interesting feature about this is that this symmetry is not accidental. It's really just the nature of markets, in particular the real market as opposed to the financial market. The distinction between buyers and sellers is actually an artifact of the existence of financial markets to mediate between goods, traders, I should say. And one way to think about this is that the buyer and the seller, they're just traders. And this would be obvious in a barter economy, for example. If I trade my mule for your horse, we're both buyers and we're both sellers. And if market concentration occurs on either side of the market, that's going to cause harm. So that's why I think, that's at a theoretical level is why competition law should apply to the same extent on both sides of the market. And now there are special features about labor markets. So I'm a little bit cautious about the suggestion that we should just think of input markets broadly. I think there's a difference between workers and firms that buy products from upstream firms. But I will put that aside for the moment. Okay, so this will also be familiar. This is American law, which is similar to European law. For the purposes of this talk, what I want to do is I want to talk about 3 cases, each of which is an example of these 3 broad categories of antitrust law in the United States. Restraints of trade, contracts, mergers, and then monopoly or monopsony, right? The 3 major types of anti-competitive behavior or potentially anti-competitive behavior that receive the most attention by regulators and courts. Now, in the United States, the interest in labor antitrust began sometime in the mid-teens and has accelerated over the last 5 years. And so now there are a lot of cases taking place. There have been criminal cases. I understand that in European law, there's no competition law crime, but in US law there is. And the Department of Justice has brought several criminal prosecutions against employers or the CEOs of the employers who engaged in either no-poach agreements or wage-fixing agreements. And just recently, a few months ago, the Department of Justice secured its first conviction. So someone will go to jail or be fined for entering into a no-poach agreement. Meanwhile, there have been a number of merger challenges. The most famous is the first one, the Penguin Random House Simon and Schuster merger, which I will talk about today. But there have been several others. The FTC was involved early on in challenging mergers among hospitals in Texas, where there's very strong evidence that the market share of these 2 hospitals that there were 2 hospitals basically that employed all of the nurses in the local area. So when they merged, the HHI would increase to 1,000 in the labor market for registered nurses. For various reasons, this merger was reviewed by a state commission. The FTC just filed a submission to object to the merger, and the mergers were allowed to go through. But this was still an important step for the FTC to take. More recently, there was the merger between the attempted merger between Kroger's and Albertsons, and another one between Tapestry and Capri, where labor issues played a central role in the challenges to these mergers, although they were blocked on basically product market grounds. Okay, and then there's been a lot of Section 1 litigation. I won't go over this with you. There's been some Section 2 litigation. So this is of great interest. I'm going to talk about this case, Lee versus Zuffa, which settled very recently. And it's the only example, but the only really clear example of a true monopsony case or Section 2 case where an attempt to monopsonize a labor market was successfully challenged. Okay, and then we have the merger guidelines. So what's been going on? And these cases are being brought all the time. I actually am involved in some of this litigation and have helped bring recent cases. One of these cases is a lawsuit against employers of veterinarians who use a kind of a matching process that we think involves collusion. It's a bit like the residential matching process for human doctors as opposed to veterinarians in the United States. I'm not sure whether in Europe you have something similar to that. But basically, it's actually very common for employers to get together and to set up some kind of system for regularizing applications for jobs. And in the course of doing that, they can also collude. Okay, So I'm going to go through 3 cases. That's my plan today, and I'm going to do this now as a lawyer. That's what I am. I try to draw wisdom from the economists, but I'm trained as a lawyer, and it's what I try to focus on. And I'm presenting these cases to you. You're probably familiar at least a little bit with some of them, but I want to show what, in practice are the difficulties and basically the difficulties, the challenges of bringing a labor market case. So this first one is the Silicon Valley no poach conspiracy. That's Steve Jobs on the left, Eric Schmidt, the then CEO of Google, on the right. You can see they're dressed very similarly. I don't think this is the particular agreement, not to poach each other's workers, but it's of a piece. So this case, I think, probably more than anything else, is responsible for the rise in labor antitrust. And so really, a lot of credit goes to economists for the empirical work they've done on labor markets. The credit here really goes to the Department of Justice that brought this case. And the Department of Justice brought this case in 2010. So it's actually quite a long time ago. But the wheels of bureaucracy sometimes turn slowly. But this case would ultimately lead to the Human Resources Guidance in 2015, and then to the challenge of the Penguin Random House merger. So it's very important to kind of understand this first important case. Now, when I call it the first case, I really mean the first important case. There have been labor antitrust cases in American, all through the history of antitrust law in the United States, going all the way back to the 1920s. But most of them are very idiosyncratic. Most of them involve sports leagues of various sorts, for the obvious reason that when you have a sports league, you have to publicize your rules restricting the movement of players from one team to another, so everybody knows about them. But there have been other challenges to restraints of trade in labor markets that have been unsuccessful. And this is really the most important recent one, okay? And I know you can't read what's in those boxes. I can't, and I'm standing closer than the rest of you. So I'll tell you what are in the boxes. But I want to start with the Silicon Valley cartel. And probably if those of you who have heard about it probably know that the Justice Department sued and immediately settled 8 very large tech companies. And that was the end of it, okay? And that happened in 2010. It's really much more complicated than that. So I've written a paper with a colleague, Ruth Zheng, and we dug into the evidentiary records, the expert reports, and the media stories at the time to try to figure out, what did happen, what happened that wasn't just in the case books that sometimes mention this case. The real story is much more complicated. So what happened is, back in the 1980s, George Lucas of Star Wars fame had started this company called Lucasfilm. And at some point he decided to sell off the division of Lucasfilm that produced computer animation. So the division and the animation workers were sold off. Steve Jobs bought this company. So he was in the wilderness at this time. He was not at Apple. And as a part of the agreement, Lucas and Jobs agreed that they couldn't poach each other's employees. Now, they may have consulted lawyers about whether that was lawful or not. And at the time, the lawyers would probably have said, no, that's okay, because this agreement not to poach workers is ancillary to the sale of a business. And if you sell your business and you can't commit not to hire back all the workers in the division of your business that you sold, or for that matter, if you sold the whole business, it would be very difficult for people to sell businesses. So generally speaking, that's probably okay. And it's probably okay today as well. So Jobs becomes the head of Pixar. And then subsequently, and this part, of course, is not recorded in history, but he apparently entered into no poach agreements with other companies especially in this animation side of the market. So this on the far right here, you have Pixar and Lucasfilm. Those are the right there. And then they have no poach agreements with Walt Disney. Steve Jobs was on the board of Walt Disney. Image Movers, DreamWorks, and Sony. So it's kind of an animation, computer animation, no poach agreement. Now these seem to have been purely horizontal no poach agreements, right? They're no longer ancillary to the business. And then Jobs leaves and goes to Apple. So Apple's right in the middle, the node in the middle. And he's good friends with Eric Schmidt, who's the CEO of Google, which is the node in the top network. And then subsequently, these agreements spread to all these other companies. And a lot of companies that people don't even associate with Silicon Valley or even tech. So Google has an agreement with IBM. It has an agreement with Dell. They're a Texas company that manufactures laptops and other computer equipment. Earthlink, Ogilvy, which is a famous advertiser. eBay, Novell, Sun Microsystems, Genentech, which is a biotech company, Best Buy, which is a big retail chain, Foxconn, which makes the iPhones for Apple, and countless other companies, or not countless other companies, about 40 other companies. Okay, so these are all employers who are one way or another associated with this no poach conspiracy. Now, I don't want to oversimplify. It's not entirely clear that many of these agreements were actually bilateral. Apple and Google had these basically do not hire lists that they maintained, and these companies were on those lists. Sometimes it may have been purely unilateral. Maybe sometimes there may have been an agreement. But the reason why the government didn't sue these other companies and that the subsequent lawyers for the classes did not sue these other companies is that if there was evidence, it was not very strong. You know, there were not email messages like this one. Okay, so this is an email message between Steve Jobs and Eric Schmidt, reading the thread from bottom to top. From Jobs, it says, Eric, I'm told that Google's new cell phone software group is relentlessly recruiting in their iPod group. If this is indeed true, can you put a stop to it? Thanks, Steve. And then Eric replies, I'm sorry to hear this. We have a policy of no recruiting of Apple employees. I will investigate immediately. Eric. So the Justice Department had a lot of emails like this. And not just between Steve and Eric, but between these various other tech executives. Okay, this continues. So the origins of this no poach agreement is in the 1980s. It continues until the Justice Department puts a stop to it in 2010. 20, 30 years. Okay. 20, 30 years, not only 20, 30 years, these companies are the largest, most sophisticated, and at the time, most admired companies in the United States. Well, some of them are not even US companies. So you have to think of these executives, consciously deciding to break the law. They surely had a tremendous amount of legal, or at least access to legal advice, which they either got and ignored or did not get. Did they know they were breaking the law? Well, you don't really, it's hard to tell, but there is this famous email. This is from Eric Schmidt to a subordinate. I would prefer that Omid, another executive, do it verbally since I don't want to create a paper trail over which we can be sued later, question mark. And the response is, makes sense to do orally, I agree. So part of the problem here is, well, so this suggests that at least Schmidt knew that he was breaking the law or thought it was likely or possible. So maybe he should have consulted a lawyer if he wasn't sure. It also suggests that most of these agreements were made orally or enforced orally, so there's no paper trail. And so we don't know how robustly all 40 or more of these firms were involved in the no poach agreement, or whether other unnamed firms were as well. Okay. So there are all kinds of interesting factual questions that also become interesting legal questions for people to think about, write about. Why was this cartel formed? I'll get back to this question in a couple slides, but at a minimum, of course, the executives were worried about losing their software programmers, their tech workers, to one another. And an obvious way to stop this is to make an agreement. Now, most of these firms, at least the firms at the center of the conspiracy, were in California, which means that they couldn't use non-competes. So this was maybe a workaround. Another interesting aspect of this agreement is that it was limited to cold calling. So cold calling is an American idiom that means basically recruiting. So the idea was, if I'm a programmer at Google, Apple is not allowed to call me up or send me an email and say, hey, come work for Apple. But if I decide I don't like working at Google anymore, and so I quit and apply for a job at Apple, Apple can hire me. That's not a violation of the agreement. And there's an interesting question, why? Okay, so here's some speculation. You're never going to have a leak-proof conspiracy. It's probably okay if one of your employees, if that employee really doesn't want to stay there, to let that person leave. So the real concern was with cold calling. The concern was raiding by a competitor. Okay, so there's a large cartel literature that I've been looking at as I worked on this paper, and it's really interesting and kind of inconclusive and anecdotal. One of the questions in the cartel literature is how is it possible for cartels to be maintained? After all, as you all know, if you have a bunch of firms that agree to, let's say, fixed prices or wages, each firm has an incentive to cheat so as to get market share from the other firms. Now, despite that theoretical point, cartels do exist, and they've existed for a long time. In this particular case, there are a couple possible explanations. One is there's a recent paper that finds that these tech companies, the core tech companies, shared their executives. And the authors call this common leadership. So it's very common for the CEO of one company to be on the board of another company, or another executive of the first company to be on the board of another company. And in fact, there are all these social connections. And so it was even quite common for, let's say, Google to consult with a person who's an executive at another company. So these authors find that the more common leaders companies have, the more the wages went down. So that is one theory. And it's actually illegal in the United States. I don't know European law to have what are called interlocking directorates. And a lot of people have poo-pooed that, that portion of the law. But it does seem like that is a mode through which collusion could take place. Another theory is just its personal relationships and friendships. And I went back and tried to find out who was friends with whom. Nobody was really friends with any, but they were kind of frenemies. They socialized together, they competed with each other, they knew each other very well. The executives, they lived in the same area, Silicon Valley, and so there were all these opportunities for them to collude if they wanted to. Many of them had mentor-mentee relationships as well. There was just a lot of friendliness and social interaction. How were disputes resolved? Well, it's very simple. From the email trail, you can see that there are email messages like the one I showed you from Steve Jobs to Eric Schmidt saying, hey, you guys are recruiting us. You're not supposed to. Stop. And that's how they were resolved. There's also a lot of discussion in the depositions about how fierce and scary Steve Jobs was on the phone. And so people were really terrified of getting a call from him complaining about poaching. So there was a kind of a primitive dispute resolution mechanism. Interestingly, also is that these no poach agreements, they were very informal. They weren't written down for obvious reasons. But as a result of the informality, they were extremely broad. They were just Google and Apple says, we won't cold call each other's employees. But this created all kinds of ambiguities. So in one case, there was a sous chef. I forget which company wanted to hire the sous chef away, but the company emails the CEO and says, is it okay for us to hire the sous chef, your sous chef, or is that a violation of our agreement? And in some cases, it was administrative assistants or secretaries. And the sense you get is that what they were really concerned about were actually the tech workers. But these companies, they employ lots of people, and they were obviously afraid to break the agreement even inadvertently by hiring a sous chef. Okay. Did this conspiracy really have an effect? So according to a very recent paper by Matthew Gibson, it resulted in $3.1 billion in lost wages. A class action was brought after the Justice Department case. They also, their expert also estimated $3 billion in lost wages. The settlement was for $400 million. That's pretty much, what one would expect in these class action cases. Settlements are usually much lower than the total damage. And then finally, how was it detected? We don't know. It's probably a whistleblower. By the time we have 30 or 40 firms involved, there would be a lot of people who would know about this. And probably, I think some of these firms felt bullied into these agreements and were not happy about them, or thought the agreements put them at a competitive disadvantage. After all, if you're a big firm, you benefit with a lot of employees, you benefit from no poach agreements. If you're an entrant and you're trying to find talent for your startup, these agreements are a huge problem for you. Okay, a few points about the law. So this case settled, with the benefit of hindsight, it looks like an easy case. At the time, it did not look like an easy case to the lawyers who were involved, because there was just so little case law on labor antitrust. But in some opinions, it was early opinions issued by the judge. She agreed that per se liability would apply to a case like this. The two real big complications are first causation and damages. So in a class action where you're trying to obtain damages, you have to show the connection between no poaching and the actual loss in wages. Now, economists can do that, but it's complicated because unlike a wage fixing agreement, you don't have a number you can point to. You have to produce a model of the labor market and then ask, if you add this additional friction, what effect that will have on wages. Class certification is also a problem. This turns out to be a big problem in labor antitrust cases because workers are very heterogeneous. On the product market side, often we're just talking about fungible goods, oil, for example, or consumer goods, which are often very fungible. But on the labor side, everybody's different. People have different skills and attributes. So this can be a problem when it comes time to certify a class. Now, because the case settled, the defendants initially settled with the Justice Department and then settled very quickly with the classes that subsequently sued. But so they never had a chance to defend themselves. But where they did try to make a defense, they brought up possible pro-competitive justifications. So one of them was need to collaborate. And they said, look, we're tech companies. We're constantly interacting with each other. After all, I make software that runs on their servers for their business. We have to be able to talk to each other so we can provide the type of software that they really need. These companies frequently engaged in joint ventures. And so, basically what they were saying is that because we need to, this is an industry in which it's very important to have collaboration, it's okay for us to impose no poach agreements or to enter no poach agreements. Now, legally, that's not going to fly because if you are going to argue that restraints are justified, they have to be tied to a specific form of collaboration, like a specific joint venture. But I'm going to come back to this point in a moment. There's also a recent interesting paper that argued that during the conspiracy, the conspirators actually engaged in more research and development. And this comes back to some points made earlier today that maybe labor restraints are necessary because otherwise employers wouldn't want to trust their employees with information that's necessary to innovate. Whatever one thinks about this paper, the actual benefit to the employers was relatively low and lower than the harm to the employees. Finally, I just want to talk about this interesting debate that's now a quarter century old. Back in the 1990s, during the dot-com boom, people began wondering, why was it that Silicon Valley has been so productive and so innovative, whereas other areas in the country, in the United States, had not been? And a law professor named Gilson wrote this kind of famous paper in which he compared Silicon Valley with Massachusetts, where there's a Route 128 corridor, tech corridor, which actually had gotten its start, I think even before Silicon Valley did, or it was reasonably mature at the time, but was just not as vibrant and innovative as the Silicon Valley firms. You probably can't name any of these firms in Route 128, whereas you can probably name many Silicon Valley firms. So there was this theory. There's an initial theory was proposed by a sociologist named Ellis who said, well, in Silicon Valley, they like the rugged individualist theory, but actually they're all pals with each other and they chum around and they create this kind of safety net. So it's easy to take risks and innovate. That was her theory. And then Gilson comes along and says, oh no, it's a much simpler reason, which is that non-competes are illegal in California, whereas they're lawful in Massachusetts. And indeed, in Massachusetts, the tech workers were subject to non-competes and tended to spend their entire careers with one firm, whereas in Silicon Valley, they were constantly moving around, or so the view was, and that led to what Gilson called knowledge spillovers. So each firm basically doesn't want to give away its secrets to another firm, but they don't mind taking the secrets of the firms from which they hire people. And maybe in some aggregate sense, that's good. So that was this debate. And the irony now, when we look back at it, is that this debate was going on just as this conspiracy was developing. So if there wasn't really any knowledge spillovers, there really wasn't that much back and forth among different firms, because as a result of the ban on non-competes, the firms just entered into no-poach agreements. Okay, that's the first case. Second, the merger between Penguin Random, or the attempted merger between Penguin Random House and Simon & Schuster. So, this was Simon & Schuster and Penguin Random House were the third and the first biggest commercial publishers in the United States. They wanted to merge. The Justice Department challenged the merger. And then interestingly, the normal way of challenging a merger like this would be to argue that the merger will hurt consumers, namely people who buy books. Maybe the merger will cause the price of books to increase. But the Justice Department decided to challenge the merger on labor market grounds and argued that the result of the merger would be to push down compensation for authors. And it's interesting to think about this choice. There are reasons for thinking you might win a labor market argument and lose a consumer argument, or vice versa, or more realistically, that one is easier to prove than the other. For example, if they had brought it on the consumer side, one argument the publishers would have made is that if we raise the price of books, people will substitute to audio or movies or TV. But that argument was not available to them because the challenge was to the labor side. And it isn't plausible to say that somebody who is a professional novelist will just stop writing novels and work for an advertising company if the compensation for writing a novel declines by a small but significant amount. So they did this, and one of the big questions was market definition. So as you'll see on the left side, this is the market definition that the Justice Department used. Authors of anticipated top sellers. Top sellers meant basically bestsellers. These were authors who would receive advances of $250,000 or more for their books. On the right side was the market definition proposed by the publishers, which was that anybody who publishes a book. And it turns out that Amazon is the biggest book publisher, because you can go on Amazon and just publish anything you want immediately. I don't think it even costs you anything, and there it is. And then there are also other small publishers that collectively, take up some portion of the market, vanity presses and so on. And the question was, well, which market definition should we use? Now, ultimately, an economist for the government showed that it probably doesn't matter that much. So you could use different market definitions. You could use different cutoffs, like $100,000 advances or $50,000 advances. And it would still be the case that this merger would be presumptively illegal under the then merger guidelines. So when the government did the market concentration analysis, it was clear that both the status quo HHI for the labor market was very high, and that the merger would increase it significantly. What's particularly interesting about this case and rarely discussed is the unilateral effects analysis produced by the government's economist, Nicholas Hill. And it was really very well done, especially from a kind of a rhetorical perspective, from the perspective of trying to get the court to understand what the likely effects of the merger would be. And so this is an example. This is one of his slides. And the key point here is that when an author is trying to persuade a publisher to accept a manuscript and pay money for it, there's an auction is held. It's not an auction where everybody's in a room and you have an auctioneer. It's just you go from one place to the other saying, they offered me $50,000. Can you beat that? And the careful records are kept of this. And Nicholas Hill was able to show that in a lot of these auctions, the last two bidders were Simon & Schuster and Penguin Random House. So if they're one firm rather than two, the auction would have stopped at a much earlier level. In this case, $650,000. But because Simon & Schuster and Penguin continued to bid against each other, it ended up at over $800,000. These are the memoirs of some famous person whose name was not released. He also looked at diversion, right? And so one question was, well, if Simon & Schuster and Penguin Random House merge, maybe it doesn't make much difference because the usual second highest bidder is a different company, Harper or these other companies, HarperCollins and so forth. But it turns out that if you're somebody who normally makes a contract with Simon & Schuster, the next highest bidder was usually Penguin Random House, or 42% of the time was Penguin Random House. So this suggested that the merger would have an impact, very strong impact on quite a few authors. And so Hill continues his analysis, and I won't go describe this, but basically this is the predicted impact of the merger on these advances. They go down anywhere from 4 to 19%, depending on which model you use. Okay, so that established a very strong prima facie case. The judge was really on it. She understood what they were arguing, and she was clearly persuaded. The merging parties tried to come up with an efficiencies defense. They really couldn't articulate any efficiencies. In fact, their expert on efficiencies was excluded from the trial. And ultimately, an executive testified about something about saving office space if they were in one building together, which was not at all persuasive or even relevant. The court was clear that if the defendants are permitted to rebuttal, they would have to show they'd have to show that the merger would cause wages to go up, not down, and consumer welfare is irrelevant, right? For the reasons that were given in the last panel, or by somebody in the audience in the last panel, which is you only look at one market, right? But I do want to emphasize that it's quite plausible that if the publishers merge and suppress compensation for authors, some authors are going to drop out of the market. It's not going to be worth it for them anymore, which means fewer books will be produced, which will harm readers as well. Okay. And then my final case study is probably the least familiar. This is Lee versus Zuffa. And this is an example of a successful challenge to vertical restraints. So the guy on the right is Kung Lee. He is a mixed martial arts fighter. And so I've never watched one of these, but I think it's basically like boxing, except you're allowed to use body parts other than your hands to inflict damage on your opponent. And Zuffa, the defendant, had this brilliant idea, classic entrepreneur 20 years ago. He had this idea that Americans would pay to watch these types of fights. They like boxing, they like football, surely they would like these fights. And in fact, the initial premise, very characteristic of the American media environment, was let's invite people who have been trained in different martial arts traditions and just have them fight each other and see, which tradition is the best, right? But, ultimately it was made a little bit more palatable and it became a kind of a mainstream sport. Now, a comment was made also during an earlier panel about well-paid athletes. This is actually, I think, an important mistake. It is true that the athletes that we've heard of are very well paid. And there's a correlation between having heard of the athlete and how much the athlete is paid, right? There are most athletes that we haven't heard of and are actually paid very badly. So I've worked on cases or studied cases where you have a very famous, a very popular sport, and then the people who are well known get paid a huge amount of money, tens of millions of dollars, hundreds of millions of dollars. But then there's this huge, it's like a power curve. There's this huge tail of people who basically make nothing. And this was actually brought home to me in the litigation over the NCAA, the college sports organization. So this litigation is going on, and some experts were hired to predict what these college athletes would be paid if there wasn't this wage fixing conspiracy where wages were fixed at zero. And the variation is enormous. Some of them would be paid hundreds of thousands of dollars because college football and college basketball are very popular and bring in lots of broadcast revenue. And some of them would be paid nothing. Nobody wanted to watch them or pay to watch them. And a lot were, and in the actual settlement that's been proposed, there's that similar variation. Some people get hundreds of thousands of dollars, some people get $100. Okay, so if you bring up the wages of the sport as a whole, it will benefit presumably the people at the top, but it might benefit a lot of other people as well. Okay, so some very clever lawyers who I guess enjoyed watching mixed martial arts bouts realized or somehow found out that the fighters, who are of course workers, were subject to quite onerous contracts. Now these contracts, they were technically independent contractors, not employees, but in another sense, in economic or sociological sense, they were obviously employees. They worked for the promoter, Zuffa. And they had to sign contracts with the promoter, and the contracts had all those terms that you see. Basically, very strong non-competes. So if you fight in a bout that I promote, that Zuffa promotes, then for a number of years, or first of all, you're under contract with us, not employed, under contract with us for 3 years, and you can't fight for anybody else during those 3 years. And then for some period afterwards, you can't fight for anyone else. We own the rights to your name, likeness, and identity. So you're not going to be able to develop an independent following. Everything goes through us. We have control of sponsorship. We have a right of first refusal if you want to go and work for another promoter, even after your contract is over. Okay, so they had all these constraints. And so a lawsuit was brought on their behalf, a class action, arguing that these restraints were vertical restraints that violated Section 2 of the antitrust laws. So the significance of this case is I think it's the first more or less litigated Section 2 vertical restraint antitrust case in the United States. It didn't get to trial. There's a settlement for $375 million. But there was a summary judgment opinion and a class certification opinion where the court said, yeah, the theory of this case makes sense. And this diagram I've put up, you've probably seen in other contexts. It's just a standard diagram of input foreclosure. So what we have here is upstream, these workers, these people who have these skills in mixed martial arts. They can sell their labor either to Zuffa and the UFC, the Ultimate Fighting Championship, that's the name of the league that he set up, or to any other rival promoters who are out there. And there were rival promoters out there. There were people out there who said, hey, you know, I'm going to rent out a venue, set up the facility for having a bout. What's it called? A ring. Set up a ring so that these guys can fight, sell some tickets and have customers come in. So there were people like that who were doing that with more or less success, but the UFC was dominant. It got dominant very quickly, partially by buying some of its competitors, right? Partially through this kind of early stage acquisition. But then, of course, when the new companies tried to enter the market or expand their share of the market, they couldn't, because when they would go to these to the fighters who were under contract with Lee versus under contract with Zuffa, the fighters had to say, sorry, I'm subject to a non-compete. Sorry, I'm under contract. Or if the contract's over, I have to first go back to the UFC and give them your offer, which they'll be able to match if they want to. And there is evidence in the record that UFC took a explicitly predatory attitude toward what was going on. They wanted to, I mean, this is, what businesses, they want to maximize profits. We don't want competitors. So they would try to lock up, especially the most famous and successful fighters, in order to drive their competitors out of business. Now, what impact would that have? It seems to have had a significant impact if the experts' reports are to be believed. None of the rival promoters were able to get a foothold in the market. The UFC becomes absolutely dominant. Why exactly? Because, I don't know, there was some branding. Some of these fighters would develop followings. You probably needed economies of scale to compete in this industry because of all the connections to broadcast and so forth. Because the rival promoters weren't able to compete, UFC could raise prices. Now, interestingly, raise prices for customers and also suppress the wages of the workers. Now, the customers, maybe it didn't make a big deal if the prices were a little higher because they could watch something else. They could watch boxing or football or baseball. Maybe not baseball. But the people who had trained as mixed martial arts fighters, they didn't have other options, not options that would actually employ their skills. Another aspect of this is that the Zuffa also tied up the broadcasters. So for these rival promoters, these entrants, not only could they not get the workers, they couldn't get the broadcasters. So they were really locked out. And I think this is something that people should think about more, that often these types of restraints, they're both product market and labor market constraints. Or or maybe I should put it this way, they're constraints not only on one input, the labor, they're constrained on another input, which is the broadcasting. In the interest of time, I'll just say very briefly, there are interesting debates in the briefing and in the opinion about what exactly the market should be. There were questions of causation. How do we determine what the effect of these restraints are on wages? In this type of case, the standard of liability is rule of reason or effects, right? Because it's vertical, not horizontal. And Zuffa, like all defendants in antitrust cases, makes a pro-competitive effects argument, which was not litigated because they settled. But they did say, look, we want to build a brand. We want people to be familiar and to be excited about these fighters, and that can occur only if there's just a single league. Now, I'm instinctively skeptical about that type of argument But to be fair, this argument does seem to be true for lots of sports leagues, which in some sense seem like natural monopolies. All right, let me just conclude with a few other thoughts. One is an argument I've been trying to make recently is that work is more important to people than consumption is. Well, not completely. You have to consume a little bit, or a medium bit. But our lives are, like we're here now working, our lives are consumed by work. We spend most of our waking hours working. People identify with their profession or with their work. They make social relationships through work. Their sense of meaning and status is tied to their work. On the product market side, when we're talking about ordinary people, there's some of that, like if you own a house or where your house is located or how big your house or maybe your car, but the vast majority of consumer products just don't have that impact on a person's sense of self and well-being as work does. So this is a reason why competition law should focus more on work than it has in the past. It's not just that there's theory and empirical evidence that suggests that there's anti-competitive behavior in labor markets. Is that it matters more to people if they don't have choice in their work lives than if they don't have choice or they have some restricted choice for certain types of goods and services that they buy. So a lot of what's going on in the United States provides grounds for optimism, at least if you think that the labor antitrust is a good thing. The courts are taking these cases seriously. These cases additional cases are being brought all the time, although still not nearly in the numbers that product market cases are being brought. They're large settlements, which is essential in the United States because so much of antitrust is funded by lawyers, basically. So they need to be able to make a lot of money to bring a case. And it's also the case, a question was asked about this earlier, that the Trump administration antitrust divisions, the FTC and the antitrust division of the Department of Justice, take labor seriously, or at least say they take labor seriously. And there is some evidence that they actually do take labor seriously. The FTC just brought and settled some cases involving non-competes. And then on the less positive side, there are some courts that seem to apply stricter standards in labor cases. Class certification is a big problem with worker cases, as I mentioned before, because workers are so heterogeneous. And the logistics of bringing these cases, as I found out recently, are extremely complex and difficult. But on the whole, I guess the future is bright. Thank you very much.